Well, welcome, Facebook viewers. We appreciate you joining for this week's episode of the Bond and Botus Facebook Live. This week, we are very fortunate to have my good friend and longtime law partner, even though she looks like she just finished high school, Amy Tanner. Amy, thanks for joining us.
Hi, thanks for having me today.
So, folks, just as a reminder, at Bond and Botus, we help people that are having money problems, and we know that after this last year, a lot of people are facing financial challenges. We want all of you to know that we are offering absolutely free initial consultations right now. We'll do them in person if you'd like. We'll do them by phone. We'll do them like Amy and I are meeting today by video, however you feel comfortable, but we want to help you. And we encourage you to please reach out for help before things get too bad. We're approaching the end of moratoriums on student loan collection, on foreclosures, on evictions. So a lot of things, unfortunately, are going to start happening soon. Don't wait to the last minute. Don't stick your head into the sand. Reach out. We offer, again, absolutely free initial consultations with an experienced attorney who can walk you through the options that are available. Today, what I want to focus on is an aspect of bankruptcy that many people really don't know about. Folks think about bankruptcy and they think of a straight bankruptcy. They think of losing assets. They think of um, perhaps losing a home or a car. But many of the people that we help don't file a straight bankruptcy. Many of the people we help use federal law to help restructure or reorganize their debt. And Amy is one of the best we have at doing that. And that's why I wanted Amy to join me today to talk about debt consolidation under the federal code. Amy, as way of a little bit better introduction, has practiced consumer law now, Amy, for, well, I won't say exactly how many years
We'll
because,
just say
again,
20 plus and leave it there.
for quite a long time. She started in high school. Now she's been with us. She works primarily out of her office in Huntsville, Alabama, and has counseled thousands of consumers over the years facing financial problems. Amy does a great job. In addition to being a good friend and a good attorney, Amy is a triathlete. She competes in triathlons, which I think is amazing. She teaches aerobics. She teaches spin classes. She and her husband, Robert, are just great people, great citizens of the Huntsville area. And Amy, we're grateful to have you here. What else am I missing about your background? What can you tell our viewers about Amy Tanner?
Well, thank you for the nice introduction. And that part would probably be highly classified. Well, actually, I grew up in Montgomery and went to school with one of our other attorneys, Gail Donaldson, down in Montgomery. I went to college and law school with her, and that's kind of how I found you guys way back when. And I went to Auburn and Montgomery down there many years ago and followed up at Jones Law School and moved to Huntsville while in law school, and here I am now. Um, so there's not a whole lot else to tell. I usually say I lead a pretty boring life. Been with the Bond and Botus firm for 20 plus years, and for sure I'll finish out my days here.
Well, we are grateful to have you. You do a great job for our clients. So, folks, what we want to talk about today, again, people have so many negative misconceptions about bankruptcy. Um, Whenever somebody sits down in front of my desk, Amy, I know they're thinking, I never in my life thought that I would be sitting in front of a bankruptcy attorney. Nobody plans on getting into financial trouble, but the bankruptcy code exists so that a good, honest person can get a fresh start, a chance to start over, to protect their assets, to preserve what they've built up, and we talk to out of debt to dignity, maintaining their assets, maintaining their possessions, and rebuilding from a bad situation. Um, Amy, when somebody comes in and talks to you, I imagine, like me, that there's all kinds of feelings. There's guilt, there's stress that they're dealing with. Um, uh, People are just overwhelmed. What's one of the first things you tell people when they sit down with you at your desk for a consultation?
And you're right. The biggest thing is stress, and really the first thing I do is try to find out what's giving the person the most problem. What are we here to fix? What did you come to see me about today? Um, and most people think, and they're not sure what to say, and you can see the wheels turning in their head and the stress and what answer is she looking for. And I'll say, are you just overwhelmed? And you can see the light bulb. Yes, this is it. I'm overwhelmed. I said, well, there's nothing wrong with that. I said, we
Right.
all get overwhelmed. It's a lot. I see you have quite a few creditors here. I'm sure that it's not fun to think about who am I going to pay every month, especially if you can't pay everybody every month. But I'll say let's talk about how we can fix this. There's opportunities to fix it. There are ways to fix it. And generally, I can see the stress well as soon as we start talking about, hey, when I say, I know I can help you, we'll get to the details later, but I'll help you with this overwhelming situation. You can see the relief kind of fall off a little bit. And lots of my clients, after they spend the first 20 or 30 minutes here with me and walk out the door or get off the phone with them, they're like, I feel better already.
Yeah.
So
We keep boxes of tissue on our desk for a good reason.
I
It's an
do.
emotional thing, but it's great to be able to give somebody a plan to work their way out of debt. Um, uh, they leave our offices and they feel like there's a big weight off of their shoulders because they have a way to move forward. Um, Again, I want to focus today on how folks can restructure their debt. Um, the primary bankruptcy code section that most people think of is straight Chapter 7 liquidation type bankruptcy. And for some people, that's what we do. For some people, a complete fresh start is right. But a lot of folks want to repay what they can. They want to make sure they maintain their assets. So we talk to them about a Chapter 13 personal reorganization. Many folks are familiar with a Chapter 11 business reorganization. They've heard of big businesses restructuring their debt. But Chapter 13 is similar, but it's for individuals. So, Amy, tell our viewers what's the main difference between a Chapter 7 straight bankruptcy and a debt consolidation?
Well, many people think of the Chapter 7 as a fresh start, and we tend to ourselves call it the fresh start, and it can be a fresh start for the right individual. It's a quicker process. You discharge the debt, which is basically not pay the debt. I always tend to use the word discharge, but then I think, some folks may not really realize what that means. And it basically means a forgiving of your debt is a terminology I like to use with a lot of clients. Your debts are forgiven. That sounds great and fine, and everybody, kind of wants to be a candidate for that. Um, Not everybody, because there are lots of folks who feel guilt about not repaying the debt. But the Chapter 7, with the right client in the right situation, can get you out from under debt. Typically, medical debt is what we look at sometimes. There are reasons we may not look at a 7 for medical debt. Um, Strictly unsecured debt. It's not going to give you a lot of help all the time with maintaining your assets. Of course, what I tell everybody's individual situation is different. So, generally speaking, it's right for certain individuals, but not for everyone. It is the fresh start. You do get your debts forgiven, but it's not necessarily the best case scenario for everybody, and probably not for most folks. Um, Typically, I file more Chapter 13s and 7s. I kind of love the Chapter 13. I like to call Chapter 13 the safe haven of bankruptcy, or the we can fix everything in Chapter 13 kind of bankruptcy. It's a little more of a long-term commitment. You're going to be in a repayment plan with the bankruptcy court via a trustee, and you're going to repay some or all of your debt. You still may get to pick and choose if there are assets you could let go that would alleviate some of the financial pressure, but you want to keep other assets. You've got some choices with what you can keep and pay for through a Chapter 13 plan, or what you might be willing to let go to alleviate a portion of the debt. And in the end, you're going to receive that discharge that you're seeking, the forgiving of the debt, whether you pay all of it, some of it, 5% of it, doesn't matter. It's just a longer term commitment to get to that fresh start. But for many, many people, and most of the folks I represent, that is the way to go. It just fits what their needs are better. There's so many things we can do. I may be jumping ahead here, but there's so many things we can do in a Chapter 13 bankruptcy. Saving your home if it's in foreclosure, we can't accomplish that in a Chapter 7. Saving your car if you're behind on payments, that's very hard to accomplish in a Chapter 7. It's typically you've got less upfront costs with a Chapter 13. That can make it a lot easier to get immediate relief from your creditors. There are other types of debts that can be managed in a Chapter 13. Tax debt can sometimes be paid back in a Chapter 13 when it can't be discharged in a Chapter 7. You can gain the benefits of discharging certain interest and penalty on that tax debt that would accrue otherwise outside of any form of bankruptcy under certain circumstances. So there's just so much more we can do with a Chapter 13 repayment plan. It's not a debtor's prison sentence. It's not involuntary servitude. You're coming into this voluntarily to restructure your debt, make payments to your creditors, maintain pretty much your way of living, and get financial freedom in a 3 or 5 year plan.
And that's an excellent answer. The thing I like to tell people, I start with the beginning. Chapter 7, the good things about it, it's quick and it's pretty complete. The entire process of a straight bankruptcy normally takes 4 or 5 months. And we can get rid of most debt you have. Now, there are certain debts that you can't get rid of. Most taxes, student loans, child support, alimony. And as Amy pointed out, if you want to keep your home or you want to keep your car, you have to be prepared to stay current on that, and make those payments following the bankruptcy. But there are some bad things about a straight bankruptcy, or potentially bad things. First, I always say, it's going to be more expensive, as you pointed out, to get started. For most people, we can get you into a reorganization plan for sometimes for little or no money down. It may be $100, it may be a few $100, just depending on the situation. But with a straight bankruptcy, it's normally going to be in excess of $1,000, and could be significantly more that you're going to have to pay before the bankruptcy is even filed. And then I ask people, Amy, I say, well, what's the biggest thing you lose when you file a straight bankruptcy? And most people look at me and they say, well, I'll lose my credit. And for most people, you and I can honestly say by the time they get to us, their credit's already shot. The thing people lose when they file a straight bankruptcy is their right to file and receive a discharge in another straight bankruptcy for an 8-year period. So, after this last year, there's still a lot of uncertainty for people out there. You may have amassed some debt, but we're not sure how things look going forward. If you file a straight bankruptcy now, there may not be good options available in the future if you get behind. Whereas in a Chapter 13, you have an attorney like Amy Tanner there guiding you through the next 3 to 5 years, available to answer questions and available to make changes if your situation changes. You can always switch over to a straight bankruptcy or modify your plan. There are things we can do to help if you're in a Chapter 13 going forward. Amy, you talked briefly about some of the way different debt is impacted if we restructure debt as opposed to just discharging it. Right now, there are more people percentage-wise behind on their mortgage payments than at any time since the Great Depression. It's been almost 100 years since this number of people have been behind on their mortgage payments. So if somebody comes in to see you and they're 4, 5, 6, maybe even a year behind on their mortgage payments, they're facing a foreclosure, how can you help them with that?
Brad, that's almost a slam dunk chapter 13 right there. And a big, if that's your only problem, if you have no other debt issues, that's still enough of an issue to come see me or come see you or come see one of our other attorneys. Some people are under the impression you've got to have all this debt or multiple creditors for bankruptcy to be available to you. That is not true. That's a definite reason to come in and see about filing a chapter 13. The way we can fix that is typically we can take everything you're behind, that 3 months, 6 months, 12 months, we call it the arrearage. That can go into the Chapter 13 repayment plan. You become current on paper with the mortgage company immediately. If we filed you today and you were 12 months behind, I would say you don't have to make a mortgage payment until August 1. Starting August 1 on forward, you're going to resume making a direct mortgage payment. The mortgage company is going to accept it. They're going to stop this foreclosure, and they're going to consider you current on paper once we file this case with the court. And then you've got a 3 to 5 year plan period to pay back all that arrearage that has accumulated over time. Um, and so it's a real relief if you're facing a foreclosure. Um, I'll throw in something here. That you've mentioned the moratoriums are coming close to an end. I suspect the mortgage companies are going to start firing off foreclosure notices as quick as possible. Getting off on another little tangent to let people know, Alabama is what's called a non-judicial foreclosure state. That means foreclosures happen fast and furious. When you get that first foreclosure notice, or if you get a pre-foreclosure notice from an attorney's office that says your mortgage has been assigned to me to begin foreclosure proceedings. If I don't hear from you in 30 days, your house is going to begin foreclosure. Please don't hesitate to call at that time. It never hurts to talk. I mean, we do, as Brad pointed out earlier, free consultations. You can come in, you can talk to me, you can talk to one of our other attorneys at that point in the game, and we can go ahead and give you advice on that. The earlier, the better if you're facing a foreclosure to get to us to stop it by filing a Chapter 13.
Again, excellent answer. What I want to add to that is, of course, the bond and bonus law offices are located throughout Alabama and Mississippi. Mississippi is also a non-judicial foreclosure state. And what that means, folks, is, as Amy said, that process is quick. You don't get something from the court. You aren't really given a lot of notice before a foreclosure sale takes place. And once that foreclosure sale takes place, there's not much we can do. You have very limited rights under both Alabama and Mississippi law to retain your home. So you want to reach out to one of us just as soon as you can. Again, it's a free consultation. We'll do it over the phone. We'll do it by video. We'll do it however you want to, but learn what your options are. One further warning is many of the mortgage companies right now are talking about modifying mortgages, which is some sort of arrangement to let you get caught up on your mortgage payments outside of bankruptcy. Be cautious. If you get a good modification and you can get it approved and everything's signed, great. But we hear all the time from individuals that they're talking to one department at the mortgage company about a modification and the other department is going full speed ahead on the foreclosure. So don't just assume because you're talking to somebody about a modification that everything's all right. Amy, another common situation we see, somebody comes to see us, they've had a job loss, they've had maybe their unemployment ran out and they haven't been able to get back to work yet, but they're behind 2, 3, 4 car payments. Now, the way we deal with a car payment is a little bit different than a mortgage payment. Can you explain how we can help somebody that's behind on their car payment and afraid of a repossession?
Sure. And just to repeat myself, that's almost another slam dunk Chapter 13. Like I said earlier, there's so much you can do with a Chapter 13 and so many issues and problems you can fix within the limits of a Chapter 13. I would look to quickly file a Chapter 13. As I said about foreclosures, they're fast and furious. Repossessions are even faster and more furious. A creditor can pick up a car very, very quickly. So what we do is work to get a Chapter 13 filed to stop the repossession of your car. Immediately when a Chapter 13 is filed, your creditor cannot come repossess your car. Our firm will do an extra touch for you. We will call your car creditor the day we file your case to let them know don't bother their car. They have filed bankruptcy. But the way we handle vehicles, unlike mortgages, where all we just do is put the arrearage in the plan and you would resume a regular monthly payment on your mortgage because that is a long-term debt. Car loans, we all know, are a shorter-term loan period. So we're going to take the entire balance remaining on your automobile debt and we're going to place that into the repayment plan. So in essence, we're restructuring the contracts you have with the car lender. So, and kind of being a conduit for your payment. You're going to put the entire balance in here. You will not make any more direct payments to your auto loan lender once we file this Chapter 13 with the court. Your payment for your vehicle will get made through your consolidation or Chapter 13 payment over that 3 to 5 year plan period. And you will get your title when that plan is complete. So you still drive your car, you still have your car, you're still required to maintain insurance, required to maintain insurance on your car. You will not make payment to the car lender. You will not be harassed by the car lender every month. Where's your payment? Where's your payment? Um, you if your car lender has, once we file the Chapter 13, if your car lender has one of those crazy shut off devices on it, they can no longer use that shut off device. So in any attempt that they might make to repossess your car, the minute after that bankruptcy is filed, Chapter 13 is filed, is a violation of the law. That's what you get when you file a Chapter 13. You get something called the automatic stay, and that's against any assets you have or any collection efforts you have. Your creditors can't continue to try to collect from you. They can't repossess your car. They can't foreclose your house. If they do, then we're talking about a whole other ballgame of bankruptcy called adversary proceedings, where you can actually sue your creditors for trying to collect debt, repossess your car, foreclose your house, whatever it may be, post Chapter 13 filing.
Yeah, again, excellent. Amy kind of breezed over. She said you can kind of modify that agreement with your car lender, but that's big. Sometimes not only can we help you keep your car, but we can reduce the interest rate, reduce the amount you're paying each month, and allow you to keep that car. Sometimes we can reduce the actual balance you owe on the car. There are nuances of the bankruptcy and of reorganization, and you need to have a good qualified attorney to work you through this, but there are all kinds of tools you can use to protect yourself. And again, that automatic stay that Amy referred to, that's an order from a federal judge. So, if Bob's Used Cars is looking for your car and trying to repossess it, the day we file your Chapter 13 reorganization, often for little or no money down, the day we file it, there's an order from a federal judge telling those folks to leave your car alone. And if they take it, we're going to protect you. Adversary proceeding means sue. We're going to sue that creditor if they do something they're not supposed to after your bankruptcy is filed, because you're our client. We're going to protect you. Amy, another issue you alluded to earlier in our conversation, something that may cause somebody to look at a Chapter 13, is if they come to see us and maybe they failed to file taxes for a few years and had to get caught up, or maybe their income for some reason was reported improperly for a previous year, but they've got the IRS or state tax department contacting them saying you owe X number of dollars in back taxes. We're going to put a levy on your paycheck. We're going to put a lien against your house. What can we do in that situation for an individual who owes back taxes?
I sound like a broken record here, but almost another slam dunk
Yeah,
Chapter 13,
sure.
because you can do so much with taxes, especially, in rare circumstances, in some circumstances, taxes are dischargeable. I don't see that a ton of times. Because in some of the situations you just described, maybe it's back taxes for a return you never filed, or maybe they have already placed a lien on your house, or some of these things. These would make it definitely non-dischargeable, a late filed tax return if it's back taxes that you never filed your tax return. First and foremost, we need you to we need you to be completely current with filing your federal and state tax returns. But if you don't not come talk to me because you haven't filed them. Let's even talk about that. We can help you in that process too. But if you do have back tax debt, whether it's federal or state, that is something that can be included in a Chapter 13 bankruptcy. You can pay it back over time. In certain circumstances, no more interest or penalty accrues. You just discharge that, or that's forgiven, is the word I sometimes like to use in place of discharge. So it's actually a savings to you on future tax debt. This automatic stay we've mentioned a few times also goes into place against your taxing authorities. They can't then offset your future tax refunds to pay that post petition or pre petition or pre Chapter 13 tax debt that you're paying in your Chapter 13. So it protects your future right to refunds from the taxing authorities. Stops them from placing liens on your home, stops them from garnishing or levying your pay or other assets at all. So it's a real good tool for handling any back tax debt that you just can't handle. I mean, the kind of key is I tell clients all the time. Lots of folks come to me who haven't filed taxes for the last few years because they know they're going to owe. So in conjunction with getting their Chapter 13 filed, we make sure they get their taxes filed as well. We can do that kind of coincidentally or hand in hand, and so that we can manage that tax debt. They've just been scared to file because they know they're going to owe. Well, we can put it in this Chapter 13, keep the taxing authorities from ever contacting you again during the life of that 13, get that tax debt paid. And don't be afraid too. We've mentioned, both of us have mentioned, what if they're threatening placing a lien on your home? So what? They place a lien on your home. We can still pay it through the Chapter 13, save your home from them seizing it. For that matter, and you may come to this, but going off on a tangent with liens, that's another big thing I see. With a lot of debtors, you may come to see me, you've been sued in the past, maybe you didn't address that lawsuit, there was a judgment against you, and lo and behold, you decide you want to do something with your property, and you find that there is what's called a judicial lien out there against your property. Again, another seemingly large problem that we can fix in a Chapter 13. I just thought I'd go on into this since we mentioned tax liens. It's and that's one of the things I typically tell all my all people who come to see me, or all people who are concerned about what the creditors are going to do. There's pretty much nothing your creditor can do that I can't undo unless they've already foreclosed on your home or already repossessed your car. If you make it to me before either of those two things happen, there's pretty much I can undo anything they've done to you. Okay, garnishments, liens. I'm probably getting a little ahead of you here, but
No, so
one thing leads to another. As I told you earlier, I could talk about Chapter 13 all day long. Well, I do.
right, right.
And so this is just another example of so many things that can be fixed in a Chapter 13 plan. If you have a lien against your property, just like a foreclosure, those can come fast and furious. They're not going to call you up or send you a nice little letter that says, hey, guess what? We just placed a lien against your home. It's going to sit there and accrue interest. These are judgment creditors. A lot of people are under the mythology that, oh, a credit card can't take my house. Oh, yes, they can. Okay, they can sue you, and they can take a judgment from a lawsuit, and they can file that with the probate court in the county where you own any real estate, or where you may hope to own real estate in the future. And they could choose to execute that lien on your real estate, meaning take your property from you. So Chapter 13 can fix all of this.
So Amy alluded when we asked about taxes, she alluded again to that automatic stay thingy. So folks, that automatic stay thingy, that means, again, a federal judge is telling not only Bob's Used Cars, but the Internal Revenue Service, leave you alone. We can help you get into a Chapter 13 debt consolidation, get an order from a federal judge telling these folks to leave you alone, and we'll protect you once we get you there. Amy, we have had some questions that are coming in from our viewers that I want to give you a chance to ask, but I'm going to take a quick, just sidetrack here before I do so. Folks, to recap, the Bond and Botus law offices are located throughout Alabama, throughout Mississippi. We help people with money problems, and we've done so for well over 30 years. But our attorneys have hundreds of years of combined experience. And at this point, with what we've been through over the last year, we are offering absolutely free initial consultations. We'll do them by phone, we'll do them by video, we'll do them in our office if you prefer to meet with us in person. We'll meet with you however you're comfortable. But don't stick your head in the sand. Um, there are deadlines approaching that will allow mortgage companies to start foreclosing on homes, landlords to begin evicting tenants, student loans will become payable again. We've been through a tough time. Reach out and get some good advice. There's no cost. You can call the number on your screen, or if you're not quite ready, go to our website, look around a little bit, get to know us, and then when you're comfortable, there's a form on our website you can fill out and let us know how you want to be contacted. We'll reach out, and again, you're not going to meet with a secretary or you're going to meet with a practicing, experienced attorney. Amy Tanner has been doing this for over 20 years now. She does great work and has represented many, many people facing financial situations. So please, if we can help you, reach out for help now to get some advice. So Amy, what we're going to do is we're about halfway through here. I am going to let you answer some of these questions that have come
Okay.
in. And then I always like to warn my guests when we get near to finishing up, I'm going to give you a chance to throw in anything that we may not have addressed, anything that you think is important. So you might want to be thinking about that as we move forward. Amy, our first question is, how do, all right, so this person maybe is not working. How do Social Security, disability, or pension or other payments factor into a personal reorganization?
Okay, perfect answer. Those are all sources of income that can be used to fund a Chapter 13 reorganization. So no problem there. You don't have to be employed to file a Chapter 13. You just, any regular source of income is good. Now, the benefit to some of those things you mentioned, Social Security, and Social Security disability and VA disability are, this is going to get in the weeds a little bit here, they are exempt from what's called the means test in a bankruptcy. And that is a benefit to you because the means test helps us show your median income. It's a test of the median income in the state and county where you reside. And if you are over that median income, it could mean that you must pay more or a higher percentage of debt back to your creditors through an organization. Whereas if you are under the median income, you may be able to pay a less percentage back to your creditors through the reorganization. Discharge some debt, pay some debt. So that's important too. The big thing is you don't have to have a huge income. You don't have to get a paycheck. You don't have to be, quote unquote, gainfully employed. Social Security, disability, VA disability, pension, unemployment. Those are all sources of income that can be used to fund or make your Chapter 13 plan payment.
Yeah, you just have to have some source of income. Sometimes it's just temporary help from a family member, but you have to be able to show the court that you have some sense of income, some source of income. Again, great answer. I wanna emphasize a couple of things here. Number one, although we can help, this is not a simple process. Amy, we try not to get into the weeds, as Amy said, but there are factors to be considered, like the means test, which can impact everybody a little bit differently. The term of your repayment plan, how different debt can be treated in a reorganization. All good reasons why you need to talk to a competent and experienced attorney. And the other thing, and I always think of this when I hear Social Security disability, I mean, even though we're bankruptcy attorneys and that's what we do for a living, our first objective, if we can help somebody avoid bankruptcy, that's what we're going to do. Bankruptcy should not be your first option. A reorganization should not be your first option. Many people don't realize that if they're receiving Social Security disability, That your creditors in most cases cannot touch that money. So there may be no need to file bankruptcy if you don't own any property. Your only income is Social Security disability. Make sure you attorney factors to necessary. At Bond and Modus, and I know Amy, who's been with us for a long time, believes this. Bankruptcy is not the first option. We look at all your options and we talk to you about all of your options. Um, Reorganization is often a great option as opposed to a straight bankruptcy, but we want to make sure we do what's right for you, and that's why we want to talk to you because everybody that consults with us, everybody that comes to us is different. Everybody's needs are different, so we want to help you. Amy, next question. If I'm about to get divorced, is it better to do a debt consolidation before the bankruptcy or after the bankruptcy? Or
That's a
after,
really,
before the divorce or after the
I
divorce?
knew what
Yeah,
you
look
meant. I think everyone knew what you
here.
meant. Yeah. Well, that's a really good question, and that's a question where I'll kind of come back to one thing you just said. Everybody's situation is different. Um, Definitely, and I tell folks this, I tell my divorce lawyer friends this, if there are money problems heading into a divorce, two things I'll say. Please come see me before you get that divorce. If you know, I prefer you come in together. If you can sit in the room together, please come see me and hear your options, whether it be, the reorganization, Chapter 13, or even if we do end up needing to file Chapter 7, because first and foremost, number one, financial problems could be what's causing your divorce, and we can fix that. And then no divorce is necessary. That is as everyone pretty much knows, the number one problem with divorce, financial problems. Um, so that's why I encourage you, talk to me, talk to one of our attorneys first, because we may just be able to put you into a reorganization plan, save your assets, save your marriage. Okay. Number two, if you're headed for divorce, no matter what, it's not financial reasons. There's some other reason that you need the divorce, but you have joint debt, you have his, mine, and ours debt. There's just all kind of debts out there. I encourage you to still come and talk to me first, because it may be beneficial to both of you, and probably in 90% of people's divorces where there is joint debt, if the debt is a problem, it's probably beneficial to file the bankruptcy before you file the divorce. There are many reasons why, and this gets into the weeds of everybody's personal situation and how it affects everyone. But when you file that divorce, there's going to be a divorce decree, hence a court order out there that says husband is to pay this and hold wife harmless, wife is to pay this and hold husband harmless. Um, and there are a couple of things that can happen with that. Number one, wife or husband may not pay that debt, and you are going to be harmed, because the creditor who's trying to collect that debt, that joint debt from you that you signed the agreement with the creditor, they don't care what what your divorce decree says. They know you're obligated to them on your debt. A divorce decree does not take you off that debt obligation just because it says the other spouse should pay that debt and hold you harmless. They're still going to collect from you. They're still going to ding your credit when it doesn't get paid. So that's one issue you have with debt in a divorce decree versus handling the debt in a bankruptcy pre-divorce. Another thing that can happen is if you're, I like to say, awarded a debt in your divorce decree,
Yeah.
then it may not be dischargeable in a bankruptcy. You may not be able to include it in a bankruptcy. You may be out on an island with that one debt that you are to pay and hold the ex-spouse harmless. So it can't hurt at all to come and talk to one of our experienced attorneys pre-divorce for those main two reasons. Number one, first and foremost, we may save your marriage. Okay. Because debt can hurt, hurt a marriage. When my husband and I were first married, that's the thing we had the most fights about, was, buying a $4 pack of dental floss when you could have bought a $2 pack. And that's the way it is most of the time. So it's just very important to come talk to a bankruptcy attorney first if there's any debt when you're looking for divorce.
Yeah, I want to brag on Amy a little bit here. She kind of skimmed over it, but I know Amy Tanner has saved many a marriage during the time she's been practicing bankruptcy law, helping people do personal reorganizations. Um, Money problems can tear people up. They can tear relationships up. They could keep you from being a good wife or a good husband. They could keep you from being a good parent. You can't sleep at night. You're arguing all the time. You may have a wonderful marriage, but for these financial issues, come in and talk to us. Even if you're not at that point where you're thinking about a divorce, come in and talk to us and let us see if we can put together a plan to help y'all work together to overcome the financial problems you have. Um, Amy, I don't want to get specific with this, but I know you've helped young couples that have been in just this situation work together. They come in bickering. You come up with a plan where they can reorganize their debt, work their way out of debt, and their marriage becomes healthy again. And they're looking out for each other going forward. Um, so again, all the more reason, folks, to if there are marital issues, if money's causing problems like that, reach out to one of us. Again, it is an absolutely free initial consultation. You have nothing to lose and so much to gain. Amy, um, will my employer be notified if I file for a personal reorganization?
Good question. And a lot of people are concerned about that when you shouldn't be. And I'm going to tell you why. Uh, no, your employer doesn't get a notice that you filed bankruptcy, but we're looking at a couple of things here. Typically, in 90+% of Chapter 13 reorganizations, your payment is going to be made via a payroll deduction that is sent to your employer. A payroll deduction, a lot of folks where a payroll deduction is a different legal animal than a garnishment. It's not the same. Your
No.
employer cannot punish you or take any action against you or I can't think of the word I'm looking any rebuttal against you for the payroll
Right.
deduction from the federal court. Okay. They have to abide by it, but they can't fire you over it. You can't lose your employment. So they're not so much notice that you filed the bankruptcy itself, but you're in most circumstances, if you are employed, your payroll department is going to receive that deduction order to take that from your pay, which they will send it directly to the trustee of the bankruptcy court to make your Chapter 13 payment every month. Another thing here, bankruptcy is public record. In some places, they actually do still publish it in the newspaper.
Not
They,
many
they
anymore.
they
It's
don't here in North
rare. Yeah.
Alabama. It's very
Yeah.
rare. They don't here in North
Right.
Alabama. So it's not as usually I say. They don't scream it from the rooftops, but it is something someone can find out if they want to. And to that end, I encourage anybody who may be applying for a job or answering questions to a current or prospective employer, be honest about your
Yeah.
bankruptcy. The old saying, honesty is always the best policy. Be honest about it, especially here in North Alabama where I practice. We've got the Redstone Arsenal, got a lot of folks with security clearances. Uh, that's another reason to come talk to me about Chapter 13. Um, to help with your security clearance, help save your security clearance, help get your security clearance back. So that's another employer sort of related question about a reorganization. But man, I probably file as many Chapter 13s to save security clearances or more than I do to save marriages here in North Alabama.
But it's that same thing, Amy. We talked about how money problems can cause problems within a family, keep you from being the best husband or the best wife you can. Folks, money problems can also keep you from being the best employee that you can be. Um, uh, I can speak from the perspective of an employee. I've been fortunate to have a lot of folks work with us at Bond and Botus over the years, and I can tell you, I really don't want somebody working for me that is dealing with the stress of collectors calling. They're up at night because they don't know how they're going to pay their bills. I'd rather have somebody that had put together a plan of reorganization, that had been proactive and filed a plan to pay back their debt and alleviate that stress. We don't want creditor calls. We don't want um, but the stress that goes along with owing debt. Amy also mentioned the important aspect of security clearance. So we have a partner, Ron Sixtus, who's one of the top security clearance attorneys nationally, and Ron's written a book
Internationally.
on the topic internationally. Actually, he's written a book about security clearance, and Ron makes it clear you're going to look better if you've got a plan to deal with your debt than if you have bills you're behind on, bills that are going unmanaged. Uh, for the same reasons you want to protect your family, um, getting your debt under control can actually help you protect your job, and also reduce any risks that you may represent to a prospective employer, again, because you have your money issues under control. Amy, do I have to sell my home, car, or other assets if I'm going to reorganize my debt?
Well, the quick answer is no. No, and that's one good thing about the Chapter 13 reorganization, debt consolidation. You can keep your assets. Okay. Most Chapter 13 bankruptcy trustees don't want you to sell your assets. They want you
Right.
to save them. They want you to file this plan and protect those assets. I said way back in the beginning, you have the power in circumstances to maybe pick and choose if you decide to keep your house or car, but you will not be forced to sell those assets in a Chapter 13. Different story in a Chapter 7 in certain circumstances. So another reason to stay off that Chapter 7 if you've got some assets. But in a Chapter 13, you're not required to sell your assets to pay creditors. You put them, you protect those assets by paying your creditors through this plan. That's one of the major reasons for a Chapter 13 as well.
Yeah, absolutely, folks. Um, I've been doing this for well over 30 years, and I could probably count on one hand the number of times that one of my clients has lost an asset, a home or a car, an asset that they didn't intend on losing. So what I mean there, sometimes you go into a bankruptcy and you say, well, I can no longer afford this house, or I can no longer afford this car, and you intentionally surrender that asset and wipe out any balance owed. Um, uh, but if we realize that that's a potential problem in a straight bankruptcy scenario, we're going to put you into or recommend a plan of reorganization to help you keep your assets. So a good attorney is going to be able to tell you before your bankruptcy is filed whether or not you're going to lose any assets. Um, but get good advice, get good counseling ahead of time. It's very important. Um, so we're working with an attorney, and I guess this person is concerned about a debt relief attorney specifically. Impact my ability to continue to save for retirement.
And no, the answer to that is no. Several things I can say about your retirement. Um, in and again, everybody's situation varies, and this point could vary depending upon where you file your Chapter 13 reorganization. So I will say that. But for the most part, you can continue to contribute to retirement plans as your normal, whether it's through a 401k at your job, even if it's a match 401k from your employer, you can still do that. If you make regular contributions to IRAs, something like that, you can continue to make those contributions to those plans for your future to build for your future. Uh, on the flip side of that, as we discussed, protecting assets by filing a reorganization, if you already have funds built up in a retirement account, 401ks, whatnot, that is protected in a Chapter 13. That is what's called an exempt asset in a Chapter 13. So, and that's another thing I see people come to me sometimes before they've done this, which is good because I'll head it off at the pass. Sometimes after, and I'm like, "Ooh, I wish you would have talked to me first." Never, ever, ever, ever. I can't say ever enough times. Cash out your retirement funds, your future security, and pay your creditors.
Right.
You're never going to get that money back. I mean, you're going to, in some situations, required to pay that 401k loan back, but it could have been double that if you
Right.
keep contributing. Paying back yourself is not the answer to debt problems ever, because your creditors cannot touch that money you have built up in your 401k. Do not liquidate that 401k to pay your creditors. Come see me before you even think of that, because you are taking what is your future security to pay these creditors, and that is not necessary because your creditors can't get to that money otherwise.
Yeah. At point, I'm going to sum for folks. So, um, dealing with your debt for some people early in life, people have made mistakes early, new in a marriage, maybe fresh out of college, or the first time you have a job making a significant amount of money, they amass debt. By dealing with that debt, whether it be through a straight bankruptcy or a personal reorganization, you can get that debt out of the way so that going forward, you can make sure to prepare for your retirement. But the second point Amy made, I can't emphasize highly enough. I know a lot of you out there have had a reduction in income over the last year. You've been out of work. Um, uh, you have not been able to bring in the same amount of money you have in the past. So, you look at, you've got this 401k with money in it, or this IRA with money in it. You think to yourself, well, maybe I should just start pulling money out of that to pay my bills or to get through this period of time. Don't do that. As Amy said, do not do that until you talk to a good, qualified financial attorney. Because while that money is in that retirement vehicle, most retirement vehicles, again, we want to look at your particular situation.
Always exception.
Most 401ks, most IRAs, most retirements, they are most completely protected from your creditors. But once you pull that money out, it's just cash and your creditors can get at it. So at least get advice from a good qualified attorney, again, which is absolutely free right now, before you start pulling money from a retirement vehicle. Um, Amy, we have a few more questions, and I'm not going to be able to get to all of them, folks, but what I want to remind you is that these Facebook Live episodes live on our firm's Facebook page and they're on our website. So perhaps you've only caught part of this, or perhaps you know somebody that may not have heard it, but may benefit or may need to know about what their rights are under federal law, how they can restructure their debt, how they can protect their assets. Please remember to refer them back to our Facebook page or to the Bond and Bodis website. And our website address is on the screen now. This information will be there for the future and available for people to review. Um, Amy, the I guess the biggest factor that I see that often will push people into a Chapter 13 reorganization as opposed to a straight bankruptcy is pride. And I mean, I'm using pride here in a good way. People, you and I have counseled over the years say, I was taught to pay my bills. I was taught to pay my debt. Now, not everybody's capable of doing that, but somebody comes to you that they've just got behind. It's been a tough last year, 15 months, but now they've got a job that's paying them more than they were making pre-pandemic. They've got some money coming in. They just need some help pulling everything together. That again is a great fit for a personal reorganization.
Absolutely.
How do you help somebody like that? How do you help them retain their dignity?
I mean, that is a great way to do it. Lots of folks just, once you fall behind, there's almost no coming back by working directly with the creditors. They
Right.
don't care. There's hardly any way to come back from that. The thing to do, the reorganization, many people come, they're like, I really want to pay these people, but I just can't do it. I've got money coming in now, but they want $1,000 a month. I've offered to pay them 150, which is what I can afford, but they don't want it, and they just, they won't take it. And what do I do? So this is a way you can pay your creditors. Uh, most folks feel better. I've tried to argue people a time or two into a Chapter 7. It would, for
Right.
whatever reason they had, it
Right.
would be better for you. No, no, ma'am. I want to pay. I want to pay my creditors. Fine, great. I think that's admirable. That's respectable. Again, nothing wrong if you're a perfect Chapter 7 client. Let's do it. But for most folks, they just have a better sense of feeling by paying the creditors back through a Chapter 13. We're going to navigate that process for you. We're going to help you through it. There's no shame in it. Um, and another thing, I was going to try to throw this in at some point anyway. You don't wait. To your point, it's a free consultation. What do you have to lose? I have people come talk to me. Well, we really didn't think we wanted to file, bankruptcy. Well, a lot of folks aren't aware of the Chapter 13, so that's a good thing. Hey, well, let me tell you about this Chapter 13 because here's kind of the best of both worlds. I call it the middle of the road kind of bankruptcy. It's the best of
Right.
both worlds, getting the relief from the creditors, yet still paying the creditors back and maintaining your obligations with them. Um, and don't put it off. If you're struggling, if you're your mailbox is full of bills every day, don't put it off. I see too many people who try to muddle through, throw a little money at those creditors for a year, 2 years. They're in here talking to me. Then we're filing a Chapter 13 reorganization when we could be 2 years on the road into
Right.
one. It's just very, very hard, to unfortunately to work with the creditors. People come to me and say, "Can't you work with the creditors and not file bankruptcy?" I can't really work any magic that you can with the creditors. They have their
Right.
reasons for acting, being the way they are about collecting the debt. So a Chapter 13, as I tell them, real proper Southern grammar. It's the middle of the roader. Um, Pay your creditors on your own time in a plan that's
You know,
right for you.
I can say this. You've already shared that you grew up in Montgomery, Alabama. Folks, I've lived in Alabama for uh, close to 45 years now. I've lived here most of my life, but yes, I did grow up north. I think y'all have a term for people that move from up north and stay down here. But I can tell you one of the things I love about the South, again, are people want to pay their debts. It's a matter of integrity. And if that's what you want to do, if you want to, you just need some relief. You just need a way to do it. You need some protection and a plan to work your way out of debt. We can help you do that. And we want to help you do that. We are offering, again, absolutely free, no obligation consultations with an experienced attorney. Even if you just have a question or two that you want an answer to, please reach out to us and do it now before things get bad. Um, I have helped people a day or two before a foreclosure sale, but I'd really rather help you several weeks before a foreclosure sale. The bond and notice law offices are located throughout Alabama and Mississippi. We have experienced attorneys. Some of our attorneys are board certified. We work with one another to provide the absolutely best representation possible. Amy, before I close, I do want to thank you for joining us. Is there anything that I may have missed that you want to share with our viewers here?
Well, Brad, as I said, I could talk more and more and more about Chapter 13, but it's really best to see us individually because everyone's personal situation is different. Don't rely on what mother, daddy, brother, cousin, sister, twice removed tries to tell you about your finances or whether or not to file bankruptcy. Come talk to us. We'll bust all the myths for you. We will get it done in a good manner and help you through. Don't wait. Don't wait until it's too late. Wait, like I said, there's almost nothing a creditor can do to you that I can't undo. But the sooner we can start fixing your financial problems, the better.
Amen. Well, Amy, thank you so much. To our viewers, I want to thank you for joining us again. I hope it's clear to you that the attorneys that work at the Bond and Bonus Law offices, and Amy is a perfect example, we care about you. We want, I often say we treat you like one of our family members if they had financial problems. Reach out to us. We'll talk about your situation. We'll try to come up with the best solution for you and your family. Um, We want to do what's best for you. Our faith's important to us. Our family here at Bond and Botus is important, and we want to help you with your finances. So until next week, on behalf of all of us here at Bond and Botus, thanks for joining us. Thanks, Amy. Appreciate it.
Thanks for having me. See you later.